Welcome everyone. Today we have our episode of JustTalk World. It is a format when we are talking with international experts, with experts abroad, about the current issues, current legal problems that we have in Ukraine. So today we have Martin Hackett. Martin is an expert of EU-funded Pravo-Justice initiative, and he is international prosecutor. He worked on Kosovo case, and also he is a barrister in Britain and have a huge experience in working with crimes related with sexual offences and also with conflict-related sexual violence. But we'll start with some technical issues. So we have offline audience here with Martin, and it's only both of us. And all our audience is online on Zoom, and we're going to talk maybe near 40 minutes. And then our audience will have possibility to ask any questions which they prefer. And Martin will ask them. I'm a moderator. My name is Eugene Krapyvin. I'm a content editor of JustTalk, and I hope that you already saw some of our materials. And if you are not already subscribed on our Facebook or Telegram or YouTube channel, I ask you to do so. So, Martin, I think that we can start with some general issues, yes. As I know you're here in Ukraine for some time, and it's very valuable for us. And I want to know, how do you evaluate, how do you appreciate our Ukrainian legal system? How does it count, how does it fight with war crimes? Because for our legal system, war crimes, it's some new areas, such a huge amount of these war crimes. And compared to other armed conflicts, we preserved our judicial system, we preserved our prosecutorial system, and I want to know from your experience on how you followed the other armed conflicts, how Ukraine seems on this situation. Are we going fine, and we will reach the justice, reach the success, or is it some problems, issues that you want to mention? So please, Martin.
First of all, thank you very much for the very kind introduction. It's wonderful to be here. It's wonderful to be in Kiev, and it's also a pleasure to be here to try and contribute to the discussion that we're having this afternoon. As regards my experience in Ukraine so far, I've been in Kiev really on and off since the start of July. I've had opportunity to become involved with cases. Obviously, I can't talk about the content of any of those cases. I've had opportunity to speak with a number of prosecutors. What's impressed me is the professionalism, dedication of all the prosecutors that I've met, especially in the light of the huge task that they are facing within the current context. Now, there are many, many crimes being committed. Crimes are still being committed. Crimes are still being discovered as the liberation takes place of parts of Ukraine as we speak. So the prosecutors, as I see it, are really trying their best to look at those crimes and look at ways of organizing those crimes to form a strategy whereby different regions, different crimes, different victims can be analyzed and assessed, the evidence pulled together and properly recorded, and then hopefully perpetrators identified and brought to justice. So to answer your question very quickly, I've been very impressed with what I've seen so far. But there's a huge task ahead.
Of course. Great. So going to some special issues, you know that looking to your experience, we choose this topic as conflict-related sexual violence, But I want to start from some prehistory. So after the liberation of the northern part of Kiev Oblast, we have this very huge discussion about revealed for us sexual offenses. And of course, you remember it. And there was some different process, like not only pre-trial investigative bodies or prosecutor's office comment this topic. Also, it was, for example, Ombudsman of Ukraine. And what we highlighted at that time, that first of all, it's huge amount of sexual offenses, and it's some kind of typical behavior of Russian soldiers, and it is a problem because we know that it was a large scale of these crimes, but in the same time, if we are looking to the official investigations in prosecutors, it is it's not so much, and it is not compared to all this process. Of course, it's connected with some latency, some very high latency of these crimes, but still, how Ukraine can reach the people who are not already reported of sexual offense. And it is not only about the events on March or on April, it's also about new liberated territories when it's also victims who are not reported because they're frightened and so on. What advice you can make to them how to reach justice in their cases?
It's always difficult to encourage victims to come forward in this particular area because this particular area has its own difficulties. These are difficult cases to prosecute. Every victim is different. Many victims simply want to lock away what's happened to them and try and forget about it and try and get on with the rest of their lives. Now, that is wholly understandable. Obviously, the victims' families are also traumatized by what's happened. So within that context, to try and get victims to make that initial step to come forward, to approach the authorities, my view is the authorities need to take a sort of multi-dimensional approach. They need to be approaching victims in many different ways. So first of all, in our digital world, obviously, the authorities can be promoting via social media the processes that they have in place in order to properly look after these victims. Because when a victim approaches any authority, there has to be some form of trust that gets developed so that that victim can properly, I feel, give a full account of what's happened to them. So first of all, there needs to be some form of outreach and advocacy from society, and it need not just be from the prosecution authorities, but it also needs to be from NGOs working with the prosecution authorities to create an overall atmosphere where victims feel confident that they will be protected, their anonymity will be protected, and that they will be looked after within the process. So whilst the authorities in looking at social media, they have to also, in my view, have victim centres. They have to have places where victims can literally knock on the door. Those places need to be staffed by proper trained people who will treat those victims with sympathy, with respect. Victims will be listened to, and thereafter the process can then develop. Now, it's difficult, again, because each victim is different and each victim will have their own traumas. So there needs to be also a system of referrals. If a victim crosses the threshold, there needs to be people there, psychologists, support people, in order to look after those victims, again, to make that victim feel comfortable. If the victim feels comfortable, there's a greater chance of that trust developing between victim and authority or NGO. If that can then develop, what we can then have is a very real prospect, in my view, that that victim can take the very great step and be brave enough to open up to the authorities and give a recorded statement. So again, to answer your question, first steps, trust, outreach, advocacy, the challenging of myths within society, myths around these sort of crimes, which somehow seek to blame the victim when it is not the victim's fault that they've been subject to these awful offences. So it's trying to look at all these factors, and this is difficult, and this in itself has to be put into a strategy, but to pull all these factors together and then create real institutions, real places where victims can go, and places where accounts can be recorded properly.
Definitely. Thank you for your answer. And you mentioned this attitude from society, and it is really some kind of general level of attitude to sexual violence. It's not so easy in Ukraine, and we see by ordinary crimes when victims of rapery, for example, some of people are accusing them that their behavior leads to it, and unfortunately we see something similar in some war crimes where, for example, there was not direct physical influence, but the victim were at the occupation, of course, and this state of occupation, of course, it leads to some not physical, but some pressure, some intent from Russian army. So yeah, it is a problem. And how do you see? How do you see Ukraine should work further with these people? I mean that, okay, victim, he or she is reported on this crime.
Yes.
And then expertise, forensic examination, it was inquiry, interrogation, I mean. And then it became this very slow going time with any results, months, 2 months, half a year, when people waiting, and our judicial system, our justice system, how we can explain to them that the result will be, but it will be not today, but in a few months, maybe years, maybe when we physically catch the perpetrator, the Russian soldier, and so on. How to work maybe psychologically with these people, and is it a role of prosecutor or investigator or some specialist like psychologist?
Lots of questions there. Again, each victim is different, and I think it's making sure that the victim is aware of every type of assistance that is available, so that when that victim is spoken to, their needs can be best assessed and they can be offered assistance from a psychologist. They can be offered assistance by way of explanation by an investigator, which I think is a good thing early in the process. And as the process develops, I think it is useful, certainly in the Ukrainian system, where prosecutors have a much more investigative role, as opposed to my system in England, where those prosecutors can meet the victims as well. Because what we're trying to always avoid, we're trying to avoid re-traumatizing the victim. We're trying to take the best evidence from that victim. And I think also we're trying to manage expectations. And I think that's very important within the context of Ukraine, because many of these war crimes offences of rape are committed in the most awful circumstances, where it might be that perpetrators, direct perpetrators, are not brought to justice. But it's still important that that victim is given the best opportunity to give their account, and for that account to be recorded with respect. But when I say manage expectations, it's about, I think, at an early stage, informing the victim of the possibility that the perpetrator might not be caught in these difficult circumstances. So again, the victim knows from the outset the full picture as regards the criminal process. And say when the victim is taken to an outreach centre or is asked to come to an outreach centre, expectations are managed as regards, right, today we're going to speak about this, how we say progress the case. Mm-hmm. These cases take a long time to progress. So I think that the workings of the judicial system, 2 to 3 months, that's a short time. I know in my system it often takes a lot longer in these particular cases to get through and get to court. So victims need to be told about timescales, as well as being told about what's open and what's for them to assist them. But also the process needs to be explained from the outset. So look, during this process, we will be interviewing you to take a full account. We've taken a very short account. That's what usually happens. The victim gives a very short account to an investigator. This is what happened to me. But the victim needs to be managed in the sense that we will have to take a full account where we will ask you these questions. After that, if you've got any questions of us, we will go through those questions. We are here to help you. That has to be, I think, communicated to the victim, and not only communicated, but it also has to be shown by the investigator, by the prosecutor, by the member of civil society, because in many ways, and this is how I see it, in many ways we can have many rules and protocols about how we look after victims, but what it boils down to is this. It boils down to an investigator in a room speaking to a victim. And that victim has to feel, in my view, that they are cared for, protected, that society does mind about what's happened to them. So that investigator not only has to follow the protocols, they have to do it in a way which shows respect as well. And respect in terms of that particular victim's needs. So it's difficult, but it's also I think for investigators, for prosecutors, for anyone, we're drawing on all our experiences in dealing with people in difficult situations and trying to show that respect, that sympathy, in order to avoid re-traumatization of the victim. And in order to get the best account, because if we do all the things right and we manage expectations and we treat the victim as they should be treated correctly, the knock-on effect of that is that the victim feels more comfortable, the victim is in a better position to remain with the justice process because they feel some trust and protection has been built up. And then we get a better statement from the victim. We get a statement where the victim, even though we're trying to avoid re-traumatization, it's always going to be traumatic when the victim has to go back through it.
When you're talking your story,
we're trying to minimize that. But if the victim feels comfortable, and I say that in the most respectful terms, given how difficult a situation and how traumatic it is for a victim of these crimes, if the victim feels comfortable, then there is also a better chance for the investigator and prosecutor acting in the correct way to get the best account from that victim. And if the best account is given, then the process can move forward, and then justice is better served for the victim and for ourselves, for society as well. So that's very much my views, but views which I think we can debate and see what questions people have later.
Maybe.
But it's a summary of the process, and I know I'll miss out things when I'm going through this because the area is so wide and is so well researched. But in the end, in my view, it comes down to this. It comes down to sitting down with someone and saying, look, what happened to you? Let's go, take it slowly. Are you all right? Are your family all right? Yeah? and showing them kindness and respect.
Yeah, well, I especially highlighted you here in Ukraine, and you have had a lot of conversation with Ukrainian prosecutors, and it's very valuable because it is a lot of literature on conflict-related sexual violence.
Yes.
True, and it is some standards, protocols, and Ukraine are trying to use them. But when we look at the ground, on the local level, well, it is a lot of problems. So we mentioned a re-traumatization, and that you're always trying to avoid it as a prosecutor's investigator. But experts in this field, they all name this as a problem number one. For example, in Ukraine, it is a typical situation when victim of sexual offense reinterrogated for 3-5 times because we have some kind of specialization of bodies, like State Security Service. They have their own investigation. National Police have their own. Prosecutor's office, as you mentioned, have powers to investigate and to conclude the interrogations, and it is really a problem. So I have also conversation with Ukrainian prosecutors, and usually they say that that victim, it's a source of information. It's a source of information as an evidence, and we are not a psychologist to help him. And even when we're trying to become a psychologist, then we emotionally became very deep in this case, and it is not good for our objectivity, for our neutrality, and it is not good for work. So, what is this balance between to be a very supportive, emotional psychologist, and in the same time, your aim is to investigate, to obtain evidences, to go to court, and to fight for the justice.
Yes, it is. It's always a balance. And like I said at the start, these cases are difficult to investigate and difficult to prosecute. So when I say that a prosecutor or an investigator has to build a rapport and treat the witness well, we're doing that within the context and framework of their own professional obligation in order to look after that victim and get the best evidence they can from that individual. It is a difficult balance, and I know from having done these cases back in the UK, these cases are emotionally draining for the lawyers. I mean, imagine the victim. If it's draining and emotional for us and traumatic, imagine how much more that is the case for the victim who has had to go through these awful events. So when I'm doing the case, that's what I'm thinking. If I feel that these cases are difficult, imagine what the victim feels, right? I'm going to try and do my best for that victim. How do I do that? Let's get the best evidence. Make sure that the victim has that support. So me as a lawyer, I'm not trying to be the psychologist, but I've got a psychologist on hand. Yeah. In case I'm making the victim aware of the fact that there is a psychologist there and there is help there. So that when the victim is with me, I put that victim at ease, and then we start talking about the events. So again, a balance, but as professionals trying to administer justice in these very difficult circumstances, in particular when it comes to conflict-related sexual violence, we've just got to try our best and accept that it's difficult and it's going to be difficult for us as lawyers as well. But think about the victim. That's all we have to think about, in my view.
Yeah, thank you, Martin. So I propose to go to more question of like evidences or legal materials. Yeah. Again, you can talk about your experience in Britain or as international prosecutor, because again, in Ukraine, we're now on the pre-trial investigation stage. Yes. And all the judicial processes, it will be in future. And now, well, the key question is what evidences should be obtained, because usually in ordinary cases, again, expertise, like forensic examination, is the first one and the most solid and strict evidence, and the results of interrogation of a person. But in conflict-related sexual violence, it is it's typical situation when a victim is so psychologically harmed, then it is days, weeks, even months when he or she reported on it. Yes. And the results of forensic examination, of course, in this situation will not be the key evidence. So how do you see the standards of maybe of evidences in international or in British or in Ukraine? So what evidences should brought prosecutor in his case to the court to convince judge that accused person is guilty?
Right. As regards that, obviously, in any criminal offence, it's not just about taking evidence from the actual victim, but it's also creating a context around that offence. And that's all the more important in conflict-related sexual violence, because obviously, if there be a situation where soldiers come to the village, then there will be other witnesses to who was there, what insignia did they have? Was it a tank unit? Was it an infantry unit? How long were they there in the village for? We can gather that sort of contextual evidence on a more general level about who was there in the village. Then the victim's family might have seen the victim taken away. You could ask questions of the victim's family to give the victim's account context. When was the victim taken away? Under what circumstances? Where were they taken? Did you see them taken? And if they say, well, I saw them taken to a barn or to a house. And then when the victim's interviewed, the victim says, well, I was taken to a barn. I was taken to a house. So already we're starting to build up an evidential picture, context of who was there from wider witnesses when it comes to military units, family members and eyewitnesses who might have been around the victim at the time that victim was taken away. And then the same individuals potentially being interviewed when they see the victim afterwards. What did you see? Was the victim distressed? Did you see the victim have torn clothes or anything like that? All those features around the victim in order to try and support the account which the victim will give. Now, what I have to say as well is even if you don't have any of those things, you can still proceed. If you just have the victim's account, you can still proceed. Because as you said, often in these cases, and understandably so in these cases, victims don't come forward for a number of months, especially in the Ukrainian context. If rape takes place or sexual offence takes place when the area has been occupied by Russian soldiers, there is no opportunity to report that until weeks later, till after the liberation. So at that point, there is less of a chance to have evidence by way of medical and DNA evidence around that victim. But that does not stop the prosecution taking place. And I think it's a myth to think that you need that. I think it's very important for me to say that it's a myth. You don't need DNA and medical evidence in order to prosecute this. You don't absolutely need additional corroboration in order to prosecute. The absence of those features does not mean that the victim is not telling the truth. The victim is trying their very best to give an account of what happened to them. The victim's going to do that. If the prosecutor and investigator, putting everything together, can develop different bits of evidence in order to support that account, brilliant. If they can't, it doesn't take it away from the account. The fact that that victim has given an account which can be placed before a court in order to convict an individual. And back home in the UK, it is often the case where victims, if they're examined a few weeks later, There aren't injuries at times that have been occasioned in these offences. So we get expert reports which say, it doesn't say one way or the other whether or not the events took place. It might have happened, it might not have happened. The examination report is totally neutral. And that shouldn't be held against the victim, that we have a report saying it's totally neutral. Yeah, that's my view anyway.
Yeah, and as I mentioned, we have some consequences of these ordinary crimes practices. So, in society really believes that for make a case of sexual violence, it should be medicine, it should be DNA, it should be some medical evidences, and it is a problem. And unfortunately, prosecutors, investigators, they also in some deeper mind believes in it. So because in ordinary case sometimes it's going for some defamation civil cases after to failing to investigate and so on. And what advice you can make for our prosecutors, investigators, how do they need to be sure that their case without without medicine, without for examination, just with the words of victims, with maybe words of witnesses, how he can be sure, prosecutor or investigator, that this case will sustain in court, because they fear that in court it was shame, it will be acquittal, and it will be much more harm to the victim than do not go with the case to the court and trying to find something else. Maybe wait for ICC and International Criminal Court say, okay, we have some typical package of cases and invite you to join it. So
again, very difficult for a prosecutor. Obviously, if there is DNA evidence there, then that can help to support the case. If there's not, that can't be the key, in my view, as to whether or not we proceed or not. When you're preparing a case, in my view, as a prosecutor, to go before the court, and this feeds into management of expectations, there are no certainties about conviction ever when you do a criminal trial. Certainly in my system, where you have a jury, you have a judge and a jury, there is always the risk that as a prosecutor, you put a case in front of a jury and you might think it's a strong case and the jury disagree with you. On another day, the jury might have convicted, but you get a different jury and they say not guilty. So you're always managing those expectations. So as a prosecutor, you have to, I think, preparing a case, you have to accept that no case, you're never going to get all the evidence you want as a prosecutor. It'd be nice to have all the evidence, but you're never going to get that. You do have to make a judgment call, is this enough? Yeah, and that's going to depend upon each case. You have to look at the victim as well, and see how that victim wants the case to proceed as well, in my view, and take that into account. Again, that's not the deciding factor, but you have to take that into account. And again, it's about managing expectations for that victim. We have this evidence. I'm confident that we get a conviction, but in the end, it's up to the judge. That's the system we all, as a prosecutor, I'm not the judge. It's for the judge to test the evidence and me to make submissions to the judge to say, this is enough so that you're satisfied that this defendant is guilty. So it's a bit of a mindset issue, and I know that mindset changes from legal system to legal system. So I don't make any criticism of any prosecutor here, definitely not, or in other systems I've worked in, but I'm just coming at it from my perspective a bit more, where we have a case, we take it to court, and we'll say, well, we'll make our submissions and push the case as far as we can on the evidence, and then it's a matter for the jury to decide. And if they say not guilty, well, that's justice. Yeah, because there is another side to justice. We've got a defendant. There has to be a burden and there's a standard of proof. fair trial rights, all those sort of things. And it's up to the court in the end to balance all those things out on hearing the evidence and make a decision. Us as prosecutors, we say we have enough. In the end, it's for the court to decide. That would be my approach. But it's always a difficult decision, and it will turn on each case.
Yeah, of course, prosecutors should decide is it perspective or not. I agree that it is a question of mindset, and we have the opposite situation. Maybe you also saw it that in legal media, some international discussions that we have on Ukraine, a lot of lawyers are not sure that Ukrainian judges will be objective, will be neutral to the questions that Ukraine is suffering from a Russian aggression, and we are the victims of a crime of aggression, and so on. And I mean that maybe in other side, prosecutors think that if we go with a few evidences, and then judge will convict the accused person, then someone can say that, okay, he was convicted because he is Russian, it was not a fair trial, it was not objective, and so on. So how to avoid this thing when people who are not in Ukrainian legal system, when they do not believe to Ukrainian judges, to believe to their objectivity in the hot stage of armed conflict, as we name it.
Well, yeah, I mean, then we're looking at the whole trial process and everything that feeds into that. Because we've got the prosecution, we've got the defence, the need for someone to be properly defended, whoever that may be, for proper disclosure to take place between the prosecution and the defence, and for the prosecutor, and this is where, say, in my jurisdiction, the prosecutor he's not only presenting the case, but there's a duty on the prosecutor to be fair, to be a minister of justice, and I presume that will be the same in Ukraine, so that the prosecutor, we have this phrase, you're there to prosecute, not to persecute. Yes, so again, it's a balance, and it's a difficult balance in these very difficult cases. But if in these cases the prosecutor sets out the case fairly, and there is a defence counsel there, the prosecutor makes submissions, then the defence make proper submissions as well, then it is a matter for the Ukrainian judges to decide on the evidence. And as long as the prosecution ensure that each aspect of the evidence is properly considered by the judges so that they can reach a proper verdict, then, in my view, the prosecutor has discharged his duty to the court. And in many ways, these cases will come down to the victim, and they will come down to identification of the perpetrator. How can you be sure in individual perpetrator cases that it's the correct person who's in the dock or the correct person who is named if it's trial in absentia? And I think the duty is there on the prosecutor to really set out in detail why we say this named individual is guilty. What's the linkage evidence? What's the identification evidence that we as prosecutors say you as judges can be sure about? And then it's up to the judges. And if the judges give a full judgment and say, we are satisfied that this person did it because the victim said that they saw the perpetrator full face, the balaclava was off or something like that. They saw the perpetrator for a considerable period of time in good lighting. And this took place before the offence took place, during the offence, and say after the offence. The victim, they were then able to get a potential photograph of the perpetrator from social media or something like that. And then the perpetrator was placed on an identification parade. That was correctly done. And the victim picks out that perpetrator. Well, if in those circumstances, the prosecutor puts that before the court and the judges accept that as a proper identification, then in my view, the judges are properly discharging their function to assess the evidence. But but it's different in every case because every case has different levels of evidence. But those are the standards, I think. I think the prosecutor's got to ensure that the case is put on behalf of the victim, but also there is a duty there as well to make sure that the proceedings are fairly done. And that's a difficult thing as a prosecutor.
Of course.
But that involves protecting the victim. But it also involves making sure the judges carry out their task properly following the law.
Yeah, for judges it is really hard situation because they should be impartial in this case.
Yeah.
But we did not mention it, but also in this hot stage of armed conflict, we had a situation with exchange of prisoners of war, of captivities, and sometimes people asked to free accused person because he needed for exchange and so on, and it's a hard question. But I have a last question before going to our evidence. Some kind of summarized our question. What is justice? What for your opinion, will be justice for the victims of conflict-related sexual violence? I mean that we mentioned in absentia processes. We mentioned that we cannot catch every Russian soldier and accuse him and so on for different reasons. But for victim, where we meet this justice to restore it?
It's a very difficult thing to measure because, I mean, what is justice? Justice means different things to different people. I know, and because each victim is different, I've had cases where victims of these sort of crimes have said to me before going into court, I don't care about whether or not this person is convicted. I just want to go into court and say what happened to me. Other victims say, I want that person convicted and sent to prison for 10 years. So already there you've got two victims have a different view of what they want out of the process. So when it comes to justice, for us as prosecutors, that's how I would judge it from that angle, from a prosecution angle. Mm-hmm. So adhering to the standards that we've touched upon as regards victim care and protection, anonymity, that victim is looked after and cared for, that victim gives a full account to maximise the chances of justice being done in court, the victim is looked after before court in the first stages, in the interview, and also at court, and then afterwards as well, that we have post-court sort of care and ongoing consideration for that victim after the court case is over. Should there be a court case? Because like we touched on, there might not be court cases because we might not be able to identify the perpetrator. So where is justice in that situation? Again, justice from a prosecution perspective, I think, can only lie in doing your best for that victim, looking after, avoiding re-traumatization. But again, that comes back to managing expectations. We get back to that other point I mentioned. We need to manage those expectations in order to get the best account from the victim, to treat the victim well, even though that victim is aware that that perpetrator may never be brought back before the courts. So in that particular set of circumstances, for me as a prosecutor, justice is served in the best possible way in those circumstances. If we get a perpetrator, then it's putting the perpetrator before the court and carrying out the full process until there's a judicial assessment. So it's many things, and for us as prosecutors, for me as a prosecutor, and for the Ukrainian prosecutors I've spoken to, it's about trying to do all those things, and then in a wider sense, justice from a wider sense, to challenge those myths about victims of sexual crime, to destigmatize, to make it easier for victims to come forward, and And in that way, from a wider perspective, justice can be served because their accounts will be preserved, and they will be preserved with respect. And that, again, can only, I think, help them, I hope, and also help society. Is that justice? Again, you judge it from individual situation to individual situation.
Yeah, of course, justice is a hard question. And in Ukraine, we have this problem when in the center of the investigation is not a victim, but a suspect, accused person, because we're trying to punish, we're trying to persecute him, but sometimes we forget about the victim and his or her interests, and it is a problem. But
I think exactly. Just to follow up on that last point, I think in these cases it has to be, like I said, avoid re-traumatization.
Yes.
But the mindset has to be victim-centric approach. It has to flip to, this is about looking after the victim and taking the victim through this difficult process, whatever it may be, in the particular circumstances of that victim's case. So victim-centric avoidance of re-traumatization.
Yeah, great. Victim-centered approach is a great word, and I agree that sometimes attitude to the victim is much more valuable from the result of the investigation and so on. Okay, so thank you for your answers, and I think that we can go to our audience. I asked you a lot of questions from my perspective, because I'm in Ukraine and I'm working in Ukrainian legal system and so on. But from your perspective, maybe you have some points that you haven't already mentioned, and it is this technical pause that you can do it.
Yes, I mean, sometimes when it comes to heightening awareness and the need for victims to, or the assistance for victims to report these crimes, another way of doing that is to identify particular areas, geographic areas, where it's known that these crimes may well have been committed. And that could involve, in my view, teams of trained prosecutors and investigators going to areas, liaising with the local prosecutor, liaising with the local mayor or whoever's in charge of the area, in order to, first of all, educate people in the area, and then to try and very discreetly get people to come forward. I know I did that. It wasn't a sexual violence case, but I did that when I was in Kosovo and we had a massacre, and there'd been numerous attempts to obtain witnesses. The witnesses had felt let down by the international community. So I took it upon myself. I literally got in a car with an interpreter and an investigator. We drove to this mountain village. We organised a public meeting, and I stood at the front of a school classroom and said, look, we are here to help. If you were involved with this, then we are here to take witness statements. Now that, first of all, met with quite a hostile response because people were scared of becoming involved. But again, part of the skill of the prosecutor investigator is to try and break those difficulties down. And ultimately, we did do that in that case, and we managed to pull the case together from that initial step, getting into the car, going out and almost searching for witnesses. Now, in cases of sexual violence, it will be different, because I don't think people are going to sit in a school hall and put their hands up and say, I've been raped. But prosecutors, mobile teams can go out and liaise and make themselves known to the people of those areas in order to hopefully encourage, destigmatize people to come forward.
Yeah, I just remember some conversations with investigators, and they described the situation after the liberation of northern of Kiev. People, they hesitate that Russian army will never come back, and that when they now report on the crimes, maybe they will be punished in the future. And again, in typical situation for Ukraine, that some refugees or IDPs, internally displaced person, they left their villages, cities, but still some relatives are there. Yes. And when they are here, or even in Poland or other countries, starting to tell their story, it can make harm to the relatives. And it is a problem. Again, it's a problem of the armed conflict that is still ongoing, and it is not comparable to situation from former Yugoslavia when the war ends. And so I see a question from Marina Ulvanskaya, and she asked about the victim's refusal from the further participation in the court hearings. So if for some point, victim just starting to ignore, refuse to participate in it, and prosecutor lost his case in the court. And how can prosecutor manage it?
It's very difficult when a witness or a victim says, "Look, I want to withdraw my support of this prosecution." And I think everything we've talked about is trying to minimize that situation. You know, the fact that the victim isn't re-traumatized, that the evidence is properly taken, the victim is looked at. So at each stage, you're trying to minimize the prospect of that. But unfortunately, it can still happen, and that can lead to the losing of the case. It's difficult. It depends on the individual case, but it's something from a prosecution perspective that, and this is hard to say, but we have to accept that, you know, we do lose cases when we get to court. The court is not it's not a guarantee that if we bring a case to court, that person will be found guilty. And it can be more traumatizing if a victim is absolutely against proceeding, for that victim to be dragged to court and forced to go through the very traumatic events again in front of the court. Now, what I would encourage in these cases, if the prosecutor is encountering difficulties with witnesses who wish to withdraw, is giving them options, saying, "Look, you've given your account here. How about we try and set something up where you could give that account via video link to the court? You don't have to go. You could be remote." And that's what we do in the UK, very much so. We actually have a system of pre-recorded testimony. So what happens is that testimony from a victim is pre-recorded. The victim's told it's going to be pre-recorded. The police officer will say, "We are now in an interview room where there's cameras here, and this testimony is going to be pre-recorded," and the officer goes through that testimony with the victim. So that, in many ways, seals that victim's evidence. So if a victim starts to become reluctant, it's trying to give that victim options in order to try and get them back on board, to minimize that victim being lost to justice. It's difficult, really, isn't it? It comes down to individual sets of circumstances. And again, that's why we've gone through all the processes to try and stop that happening.
Yeah, thank you, Martin, for your answer. And I have two questions more. And Andriy earlier on ask you that do you see this problem in Ukraine when civil society, some organizations who want to help, who want to collect evidences, media, when they participate in this informational wars and struggling with Russian propaganda, they trying to tell the world of the crimes of Russian soldiers. And it can traumatize the victims. So should we prohibit to have any contact with media or civil society, or it could be some form that victim can tell her story or his story, but still it not harm her or his?
Again, it depends on the victim. Obviously, if the victim's going to give an account, there is to the press or to certainly to the press, then there is a greater chance that that victim's anonymity will be lost if the press publish names, if the victim's account with a name goes out there, and that can potentially cause the victim difficulties. But again, it's getting back to the first principles that we talked about. When that victim first comes forward, if the authorities can put the right structures in place as regards the victim care, then I think it minimises the chances of that victim, first of all, having to give multiple accounts to the authorities, but also it might be part of the conversation where you can talk to a victim and talk about media. If media come to speak to you, what would you do? We would, as a prosecutor, I would discourage it. I would not want a victim of mine being interviewed by the media, because I know the media are trying to publicise what's going on, but where does that leave the victim? And the victim might think in that half an hour that they're telling the account to the media, but if it's then publicised, that can have an effect on the victim. So I would be discouraging that, but all situations are different. So when it comes to civil society, sometimes NGOs are working with the prosecution office. NGOs are often the first responders there. They're on the ground and they're taking the first account, and then they're referring on to, and the NGOs, I would think, are bound by confidentiality. I would hope that the NGOs passed over the information, or as best they could, the information, if the victim consents, to the prosecution office. So that assists the prosecution office then in preparing further their file. So again, there's a lot going on there. Again, it's difficult, as I keep repeating, but it's trying to manage the situation as a prosecutor, because what you've got to think, again, it's about keeping the victim safe, getting the best evidence, in that keeping the victim safe context, and then trying to develop that to the best case you can at trial. Lots of things to balance there, but it's part of the job, unfortunately.
Yeah, definitely. Thank you. And we have two questions from Vasil Martinuk. First is it some difference between the distance participation in judicial proceeding, like by video interviewing of victim, or to presence in the courtroom? Yeah, is it some difference, or it is the same?
Difference to the ultimate outcome in the case. That's what they're asking. I think in front of juries it can make a difference. I think it should make less of a difference before professional judges. But again, if it's done properly and managed properly by the prosecutor, the evidence via video link can be just as powerful as if the witness was there. And again, it's a balance, isn't it? Because as a prosecutor, we don't want to we're trying to avoid traumatization, and we're trying to serve justice by putting the best evidence before the court. So those options are put to the victim. In my experience, because, and I'm not quite sure what happens here in Ukraine, but in the UK, you would have a pre-recorded interview played to the jury, and then that victim would be questioned over the video link. They would be in court, in a room in court, but not actually in the courtroom. And then they're cross-examined by the defence, then re-examined by the prosecutor over the video link. Now, difficult, it's always difficult to build up a rapport over that video link, certainly if you're prosecuting. But that also means that you've got to meet the victim first before the victim's called to give evidence. And again, as a prosecutor, you've got to try and do that communication and manage expectation prior to cross-examination or re-examination, I should say, of that particular victim. Does it take away the evidence from the evidence to have a video recording or a video link? Depends on the victim again. Sometimes it can, but if it saves re-traumatization, on balance, I would prefer that. Unless the victim is adamant they want to come into court, I would rather they were doing it via video link. And I think it would have less effect, as I said, first of all, in front of professional judges.
Yeah, thank you. And second question from Vasil, and it is common question. So for our judicial system, still do we need some special court or special chambers, or even on international level, for war crimes, for conflict-related sexual violence, or our local judges are qualified enough to make these cases? Because, you know, when I explain to people abroad that our first instance judges, like local judges, they're here in war crimes. So for them, it's something unusual, because it is a question of qualification, it is a question of priorities, question of the hardness of these cases, and so on. So how do you appreciate Ukrainian judges like this?
I haven't seen any Ukrainian court cases yet, so I'm very reluctant.
It's near 10 of them.
Yeah, any opinion on Ukrainian judges? I'm sure that they will apply the law as they see it and do it in a proper way. You've also got the appeals process as well, which will do exactly the same. It's difficult because war crimes cases are I mean, prior to the conflict, very unusual. Not so much now. English judges, they don't hear war crimes cases, do they?
Yes.
But they do hear lots of sexual violence cases. I think it comes down to training, Judicial Institute, judges getting together and talking to each other, being made aware of international standards, how to assess evidence in these sort of cases, being aware of the myths as regard that go with sexual violence cases, and not adhering to those myths like we've talked about. And really, in the end, for the judges to assess the evidence correctly, that's placed before them. And again, that's down to the duty of the prosecutor as well, to put the evidence properly and fairly before the court. And if the judges need guidance, for the prosecution to give the judges almost a route to how they decide the case. This is the evidence. These are the particular elements of the crime. We say these pieces of evidence support these particular elements of this crime. If you are satisfied on these elements, you can convict as regards these charges. So it is difficult for judges because they will be overwhelmed now, I think, with these very difficult cases. We all need training. We all need kept up to date in this area of law. We all need to be constantly reminded about international standards. Judges are exactly the same. I'm exactly the same. Prosecutors who work here are exactly the same. So if they get that input from the whatever in Judicial Institute terms you have here, I think they are capable of deciding as regards cases of single perpetrator. I think it's a lot harder when you come to wider, larger cases, when you're looking at military campaigns and everything like that, for judges in any jurisdiction to pull the evidence together and for prosecutors to assimilate that evidence. So that's where the debate about any international tribunal or not may come about as regards those bigger cases, which will have to be pulled together from those single perpetrator instances.
Yeah, I agree. And I also don't hesitate that Ukrainian judges, and we have unified status of judges, they're all the same, and it is the same standards of their work. So for me, it's more practical issues like the lot of cases, like when judge working with criminals, civil cases, court of administrative offences, and already war crimes. Well, it is a lot, and it could harm the evidences and quality of proceeding. But if it is a priority and it is enough time for the case to be deep in it and so on, I think it is not a problem also. And we have the last question when. It is a very wide question, but I try to focus it. So, you know, this Rome Statute has responsibility for the chain of command, this common responsibility for commanders. And in Ukraine, in our national criminal code, we do not have such things. So in Ukraine, it's individual responsibility of the person. And how do you think in conflict-related sexual violence, it could be chain of command responsibility, or it is just in every case individual responsibility of a Russian soldier who commits this sexual offense?
I think it can be chain of
command.
Can be. Yeah. Right. In the right circumstance, again, it's looking at the individual evidence, what the commander failed to do as regards the troops under his command, and thereafter drawing up the relevant criminal charges under whatever jurisdiction.
Yeah, I agree. So I have in mind this Bucha massacre situation, and we have like intelligence information from CCU that commanders, they know everything, and they neglected to act because it was their strategy to frighten the civil population. And I agree that in this case, it could be a common responsibility. Anything, nothing on the way of it. Okay, it was a last question. Martin Hackett was with us. Martin is expert of Pravo-Justice, EU-founded initiative. He's international prosecutor and current barrister in Britain. And I'm very glad that Martin have possibility and share with us his experience, because in Ukraine, conflict-related sexual violence is a priority, of course, for prosecutor's office, for investigations, but still it is a lot of questions in society, in legal community, from prosecutors, because some patterns of behaviors that we have in orderly investigation of sexual offenses, they some kind of cover the unordinary practices that in war crimes we have. So it's very valuable information for us. It was JustTalk World episode. Previous episodes you can find on YouTube channel, both in English and Ukrainian, or in English with Ukrainian subtitles, if it's not translation. And I ask you to subscribe our channel, and there we will put announcements of the further meetings with other experts. And I think that it is not our single meeting with Martin, and I hope that we will have the possibility to have a conversation in future.
Yes.
Thank you, Martin.
Thank you.
And thank you for the audience, for everyone who were with us. And I hope that it was fruitful for you too. And it was interesting to discuss Ukrainian legal material with international experts such as Martin. Bye.